All right. Good afternoon again, everyone. Thank you so much for joining. Thank you for joining this webinar brought to you by the Presser Law Firm, your asset protection attorneys. Today, we will be talking about copyright and asset protection. I know many of you believe we probably were going to be speaking about estate planning, but we'll tie that in towards the end. But today, our conversation will evolve around the topic of copyright and asset protection. All right, my name is Akhenaton Pierre. I'm one of the paralegals here with the firm. Just to give you an overview of what our conversation is going to involve today, we're going to talk a little bit about what is copyright, who should register their copyright, how to obtain a copyright, the bundle of rights when it comes to dealing with copyrights, the elements of copyright infringement, and copyright in relation to asset protection. So let's go ahead and get started. All right, so what is copyright? Well, copyright is a federal protection authorized by our federal government. And what it does, it allows individuals to have protection from unauthorized use of their protected work. Copyright falls in the category of intellectual property and essentially protects all of creative works. And we'll talk about specifically what types of creative works. It is covered under the Title 17 of the United States Code. In Section 102 of that code, it defines what copyright is. And it says that copyright is an original work of authorship fixed in any tangible medium of expression, now known or later developed from which they can be perceived, reproduced, or otherwise authorship include the following categories. We're going to list out for you just a few of those categories, and we'll dive into it a little bit deeper as we move forward. Literary works, musical works, including any accompanying words, dramatic works, including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, and other audiovisual works, sound recordings, and architectural works. Now, it's very important for us to note this here that in no case does copyright protection for an original work extend to certain things as ideas, procedures, processes, systems, methods of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such a work, okay? It's very important for us to also note that copyright is not trademark and it's not patent. Trademark protects names, taglines. It helps consumers identify the source of what they're buying or using. And when you think about patents, patent protects inventions and discoveries, ideas, devices, methods, concepts. Copyright, on the other hand, it protects the expression of those ideas. And again, as mentioned before, copyright is governed by federal law. Constitution gives Congress the power to protect creative works. Now, who should register their copyright? These are some of the people who should register their copyright: recording artists, singer-songwriters, photographers, graphic designers, authors, essentially anyone who seeks to protect the expression of their creative work. Generally, only the creator can claim copyright of their work. If there are two or more creators, there's a presumption that each owns the work equally. Now, it's important for us to note that jointly owned copyrights usually entitle each of those owners to full use and enjoyment of the copyright work. We'll talk in a little bit about what exactly are the use and enjoyment that you get when you have a copyright. Now, there are exceptions to this. We have work for hire, which essentially is work that's made within the scope of an employment. Usually in those instances, the work that is created is not owned by the employee, but rather by the employer. Copyright, it protects the way the idea is presented rather than the idea itself. Your copyright may be worth more than you think. It is imperative that one considers to register their copyright. So whether you fall in these categories or not, it's very important that you consider registering your copyright. Now, how can you obtain a copyright? Copyright is created upon the creation of the creative work. There's nothing else that you have to do, nothing specific in order to have a copyright. So upon creation, automatically, when you create the original work in some tangible format, you automatically get that copyright. You aren't required to do anything. Now, if one wants to enforce their rights in a copyright, or they want to defend a copyright, then it has to be registered. And how do you register it? You register it with the US Copyright Office. We have a link here, copyright.gov. Typically, a copyright registration can cost you between $35 to $55. You have the option of doing it online, or you can also mail in a physical copy. As discussed before, registered copyrights are governed by the Copyright Act, US Code Title 17. So once you register your copyright, you can now enforce the rights that come along with the copyrights, which we're about to discuss. Not only can you enforce it, you can also defend those rights. Excuse me. So let's talk about the bundle of rights that comes with copyrights. Copyright protection grants the owner of the copyright the exclusive right to control what can or cannot be done with the protected work. So granted by the laws of the US under Title 17, there used to be 5 specific rights, but now there are 6 rights that one can either enforce or defend once they choose to register their copyright. The first right is the right to copy a work. What does that mean? Essentially, that means to make a copy, whether that's making a copy on a copy machine or making a copy of an MP3, a copy of any type of sound recording from the master recording, making copies of sheet music. The second right is the right to make a derivative work. The term derivative means derive, made from. So essentially in the example, let's say of music, you're taking a sound recording and you're either gonna resample it or remix it to make it your own. The third right that's granted to you is the right to distribute to the public. That means either to sell, to rent, to lease, or to give. For example, let's say a picture that's taken from social media and you decide to make copies and distribute it or to print it on a t-shirt, okay? And again, let's talk again about the sound recording. It doesn't have to necessarily mean that you're taking it and you're charging people for it, but the fact that you're taking the sound recording and you're distributing it to the masses is an infringement upon the rights of the creator. An example of a sound recording, if you ever heard of the phrase piracy in the early days of Napster, when music was able to be uploaded onto the Napster platform and downloaded by visitors to the site for their own use. The fourth right that comes with the bundle of rights of copyright is the right to perform in public. For example, this applies to literary, musical, dramatic, choreographic works, pantomimes, motion pictures, and audiovisual works. Only the owner of the copyright has the right to perform their work in public, unless they grant it. In the example of music composition or sound recording, we have what they call performing rights organizations. And these organizations are there to help administer and to ensure that copyright owners are not having their rights infringed upon. We call them PROs. We have ASCAP, BMI, and CSAC. Another example of the right to perform in public is, let's say you go into a movie theater, or you're watching a show on Netflix, or you're watching your favorite band perform a live concert, or seeing one of your artists perform at a live concert. The fifth right that comes with the bundle of rights is the right to display in public the copyrighted work. This again applies to literary, musical, dramatic, choreographic works, pantomimes, motion pictures, and audiovisual works. The sixth right that comes with the bundle of rights is the right to perform publicly by means of a digital audio transmission. When you're listening to music on Spotify, or you're listening to music on Pandora, or you're listening to music on Amazon Music, these platforms have to obtain the right in order so that we can stream these music and listen to them. Now, by us streaming it, we're not taking ownership to the music, but we are given the right to listen to that music. This is why, let's say, for example, you subscribe to iTunes Music and you decide to stop paying for your subscription. all the songs that you downloaded on your iPhone or on any of your devices are immediately deleted because you no longer have the right to stream it. So these are the 6 rights that comes with the registration of a copyright, or just by virtue of having a copyright. Now, it's important for us to note that licensing copyrights has become one of the most financial benefits from their use. So by having these exclusive rights, you can license out these rights. People will be interested, and you may be a business and you own a copyright, you can license the rights. You may be an individual and you either created a song, or you did a art piece, or you're a photographer and you took some pictures at an event or something of that nature. You have the right now to license that copyright, the exclusive right that you have in that work of art. Now, licensing, it allows you to give other people authorization. You can limit their use. You can determine the time period that they can use it. All of this is negotiable, and you can base it on the agreement that you have with the other person. Now, keep in mind, when you decide to either license your work of art, it does not limit your exclusivity to the work that you originally had, nor does it prevent you from licensing it to others. Now, let's talk about what happens when a person decides to infringe or to do something against the right that you have in your copyright. To prevail on a copyright infringement claim, there's 2 specific things that have to be shown. Number 1, you have to show ownership of a valid copyright. Now, some may argue, how do I show ownership if I don't register? Well, this is why we recommend that you register. Because by registering, you have a presumption already established that you have the exclusive ownership to that work. The second thing that must be shown is that the defendant, the person that you're claiming, has infringed on your rights. You have to show that they copied one of the protected elements of your work. So going back to the six elements, the 6 rights that we talked about, you have to show that the defendant either infringed on your right to copy, the defendant infringed on your right to prepare derivative work, the defendant infringed on your right to distribute, the defendant infringed on your right to perform publicly, on the right to display in public, or even the right to perform publicly by means of digital audio transmission. You have to show that. Now, there is the possibility of seeking a criminal offense, but there's 2 additional elements that would have to be shown. The first one is a willful act, right? And what does that mean? A willful act simply means that the person acted intentionally in a way that violated the law. They knew that you had a copyright protection. They knew that you owned the work that's in question, but they infringed on it anyways. The second thing that you'd have to prove, the second element in order to pursue a criminal offense, is that the individual who infringed on your rights, they did it because they were seeking to obtain some commercial advantage or private financial gain, showing that the defendant intended to make some money, right? Or obtain some other gain from their infringement just beyond just casual personal use. Now, it's important to note that it's not necessary to show that the defendant actually gained anything, but simply the fact that they had the intent to obtain a commercial advantage or private financial gain in your protected work. Now, to put all of this into perspective, there's a case came a few years back, Robin Thicke and Pharrell Williams versus Marvin Gaye. And in this case, the estate of Marvin Gaye argued that Robin Thicke and Mr. Williams stole the general vibe and certain percussive elements of the song Got to Give It Up. This was on their song Blurred Lines, which was really, really famous. I believe this was back in about 2013 or 2014. And eventually the court ruled in the estate's favor. And they won $5.3 million in damages plus 50% royalty. This was by far one of the biggest payouts in music copyright history. So we say all this to say that it's important to understand that your copyright is important, your creative work is important, and it's important that you understand you have a copyright to it, and that you should definitely have it registered. You should definitely put yourself in a position that you can protect what is being done with that work. You don't want to take your creative work and just allow individuals to infringe on it or to use it as they please. You want to make sure that you have control or whether or not they can perform it in public, whether how it's being performed, when it's being performed, under what circumstances. You want to control that. Why? Because that is an asset. Okay. And this is what it boils down to. Copyright is an asset. When you think about your creative work, when you think about you being able to express it in a way that no one else could. I'm a musician and I love music. And when I think about the time that artists take in the studio, the energy that they have to put in the studio in order to put out amazing music that their fans can listen to, your ability to take all of that and to put it into a frame so that your fans can enjoy it, you want to protect that. And just for example, look at that, going back to the Robin Thicke and Marvin Gaye situation, $5.3 million in damages isn't small money. So your asset, your creative work, which is an asset, may have tremendous value to it. So as we transition to talk about copyright as it relates to asset protection, it is important, okay, that you protect your creative work. It's important that you understand you have a copyright. It's not only important for you to protect your tangible works, your tangible assets. For example, we love to protect our cars. We love to protect our savings, our cash, our retirement accounts, the house, our business interests. But what about the intangible assets, the intellectual properties, right? Your copyright, your patents, your trademarks. It's important that these things are also protected. And you don't just want to protect it for yourself. You also want to protect it for your heirs, right? Many of us who have valuable assets, we intend to pass it down to our children or to someone that we care of. And when we think about estate planning and being able to set it up so that your children can benefit from it or whoever you desire in your will to benefit from it, you want to make sure that it's protected, okay? You want to make sure that it's protected. It is important that these intangible assets are given as much value just as we give our tangible assets. Intellectual properties are not immune from creditors, okay? So it's important for us to understand that if we aren't protecting these assets, we're making ourselves vulnerable for them being seized by creditors. How so? Well, let's just say, for example, that you own a business and this business owns copyrights. And for one reason or another, you have a creditor that comes after you, or you may have someone who decides to sue you. All the assets of the business are at risk. So it's important to consider, what can I do to protect my copyright, right? Copyright is, to me, a first layer of protection. It's really good to have that. It's really good to have it over your creative works. Well, but how about beyond just the creative work being protected by copyright? How about protecting it from judgments, from judgment creditors? How about protecting it from lawsuits, from divorce? How do I protect these assets? There are a lot of examples of celebrities and artists who pass away and their estate, their heirs are fighting over, rights to royalties, rights to copyright. That the family say, hey, I should own this, or you should own this, and I should get the benefit of this. It's extremely important that we keep these things into consideration. One would be extremely short-sighted by simply focusing on potential infringers and just taking that first layer of protection and obtaining a copyright or registering their copyright. We believe that it's extremely important that in addition to having that copyright, that you take those necessary steps. Am I supposed to create another entity in order to shield this specific copyright from creditors? How do I do this? Do I do it through an LLC? Do I do it through an S Corp? Do I do it through an LP? How do I set that up? And for those of you who are still here at the Presser Law Firm, that is what we specialize in. We specialize in making sure that we find the best way to protect your assets, to make it, if not impossible, make it extremely costly, all right, for creditors or potential plaintiffs to come after your money. If it make it extremely costly to the point that they don't want to pursue it, or they want to just give up, okay? Extremely important. I like to say that even where a creditor or a lawsuit, a plaintiff may not want to own your copyright, they may, knowing that you own a valuable copyright, they may want to use that as an opportunity to negotiate. right? As a negotiation tactic or to leverage to get more money or a higher settlement out of you. So we like to say that if you're simply just registering your copyright, you have that first layer of protection, but you're not shielding it from creditors, you're exposing your assets to creditors. And that's never a good idea. Can creditors get your ownership to your copyright? Potentially, yes. We just gave you an example about owning a business and that business owning a copyright. I have a few friends of mine who are music artists and they have copyrights in their music. They have copyrights in their sound recording. They have copyrights in the lyrics. And these copyrights, for many of them, have a lot of value, right? They've obtained a lot of royalties through it. If they own no tangible assets and they were to be sued by a creditor, okay, by not having some sort of asset protection plan that lines up with their goals, they are potentially exposing themselves to liability. And you don't want that to occur, okay? So it might require extra steps for a creditor to actually take the rights to your copyright, but it doesn't suggest that it's not possible, okay? Upon research, it shows that they may have to file a UCC or they may have to register with the Copyright Office, the US Copyright Office, by filing the proper paperwork, but it's not impossible for that to occur. How do you protect yourself? Well, you got to shield your assets. You shield your assets by putting together an asset protection plan, a plan that can make sure that not only that is protected from the creditors, but is incorporating your estate planning so that when your time is over and your assets are being passed over, that your heirs, your family doesn't have to worry about creditors coming after your copyrights that you owned, okay? And many of us, too many times, we make the mistake of seeking to protect our most valuable assets only when we think it's too late, right? We wait for an actual lawsuit to be filed. We actually wait for a creditor to say, hey, I'm coming after your copyright. And unlike certain things like cryptocurrency, one can find out if you own a copyright. They simply have to do a search with the Copyright Office and they'll know what copyrights you own. So I like to say, and Hillel Presser likes to also say, don't insure your assets after something goes wrong. Insure it before it goes wrong, okay? So growing up, my mom had a mantra that she'd always share with me. She said, hey, son, don't prep your bed when you come home. You want to do it before you leave so that just in case you come home, you're real tired, you don't want to have a bunch of stuff on your bed, right? You don't want to have clothes just laying on the bed doing nothing. No, fix your bed early in the morning when you wake up, so that when you come home, you can just jump on it. How does that relate to asset protection? What does that have to do with asset protection? Well, essentially what we're saying is that if you prepare yourself today, you won't have to worry about the creditors that will come after you. And notice we say will, because sometimes people argue, well, maybe a creditor will come after me, or I don't think a creditor will come after me. Well, you don't know when you might get into a car accident. You don't know if you might have a divorce. You don't know if things may become adverse with your business partner. So it's very important that you consider all the steps that you're taking today to ensure that your assets are protected. And I know we spent a lot of time discussing copyright specifically, but that goes for all other intellectual properties. That includes trademarks, that includes your patents. If you're a business owner and you're on the webinar today, it's important for you to consider what patents do you own, what trademarks do you own, and how can you protect it? Aside from just registering it, right? Registering just makes sure nobody uses it, nobody can duplicate what you're doing. But how do I protect it from creditors? How can I make sure creditors don't have their hands on it? Okay. Now, just to recap, the world of intellectual property, it involves the steps and the methods of using copyright, trademark, and patent law to protect one's ideas, expressions, and inventions. Okay, oftentimes the goal is to protect others from using our intellectual property, overlooking the exposure to what could possibly be your most valuable asset. Your original idea or creative work is valuable, okay? Its potential value can be considerably great. So it's very important not only to protect it from infringers, but also from claims by creditors. Protecting your assets is not an option. It is a need. From my experience to asset protection, I've learned it's not an option. You shouldn't decide whether you should or shouldn't protect your assets. Everyone should protect your assets. And it doesn't matter the value of your assets, whether it's worth millions, billions, or just a couple $100,000, your asset is worth protecting. So if you own any copyright today, if you own any trademark or even any patents, and you want to know how can you take those extra steps to ensure that your assets are protected. We aren't able to take any questions today. However, you have the opportunity to reach out to us. You can submit your questions by email. Our email address is info@assetprotectionattorneys.com. Again, that's info@assetprotectionattorneys.com. In addition to that, if you want to get some more information about asset protection or to schedule a call with us, you can schedule it by going to our website. You can also sign up for our weekly newsletter. You can request copies of our asset protection books. The owner of the law firm here, the founder, Mr. Hillel, attorney Hillel Presser, he wrote a few asset protection books that would be of very good value to you to give you some more information. Or if you just want to schedule a complimentary preliminary consultation, go to the website. There's also the phone number at the bottom of the screen. You can reach out to us. This was a pretty brief but concise webinar about copyright and asset protection. We hope the information was valuable to you. Thank you so much for your time. We greatly appreciate it. Have a good one.